Good morning everyone and welcome to another TPN webinar. Today is the first of a series of 5 webinars on the practicalities of leasing and sales. My name is Greg Mason, I'm the head of legal at TPN Credit Bureau, and with me today is Ines Wilson, the head of rentals at Jarvis Properties, Silna Stain, managing director of SSLR Incorporated, and David Hutchinson, founder of Property Inspect. Welcome everyone, thanks so much for being here today, it's great to have you. Today we're going to be discussing specifically property inspections and navigating the minefield that can be property inspections. Just a bit of housekeeping before we get started. Make sure you are logged into your YouTube. Excuse me. Logging in makes sure that you can access the live chat. Please get involved there, ask us questions. Those questions will be fed to us, and at the end of the session we'll be doing a short Q&A where we will be discussing those. Also, if your video is looking slightly blurry, please click in the bottom right hand corner of the screen. There's a little cog icon. Make sure that that icon is at least at 720p or higher. Finally, during that Q&A session at the end, there will be a feedback form posted. Please make sure that you complete that feedback form and submit it to us. That ensures that you can get your unverified CPD point and gives us great feedback of what you might want to see in the future. So today we're going to be talking about property inspections, something that you're all very, very familiar with. Silna, I think we're going to start with you to give us a little bit of a context of the background of property inspections, particularly with the Rental Housing Act which came in.
Yes. Greg, it's actually, thank you so much for having me. I'm so excited about this. I know everybody watching this is obviously desperate to get some information and actual proper enforceable answers to do inspections, and especially with the promulgation of the Property Practitioners Act. Obviously, there's a whole new set of questions. So exactly. I'm very excited to be here. Thank you so much for having me.
It's a pleasure. And so we are doing the practicalities of leasing and the practicalities of sale. So ordinarily, where you'd hear some legal training, you'd hear a lot of legislation, you would hear a lot of in-depth acts on exactly what needs to be done. But we want to focus more on what's going on the ground in the practical sense, which is why we also have Ines here, who, as a property practitioner, you have seen inspections a lot, I'm sure. And David Hutchinson from Property Inspect. We're going to discuss the idea of outsourcing your inspections and technology that might be available in the market. Great. So, Silna, in terms of the Rental Housing Act, first of all, let's get the legislation out the way.
Yay.
What does the Rental Housing Act specifically say about your incoming and outgoing inspections?
So, your incoming and outgoing inspection in terms of the Rental Housing Act, luckily, doesn't leave a lot of room for interpretation and negotiations and things like that. It simply says, in terms of section 5.3d, it starts there, and then there's a whole list of subsections that's relevant to inspections. The long and the short of an inspection in terms of the Rental Housing Act is, if you do not do your inspections properly, your entry and your exit inspection, you will not be able to claim for any of the damages caused by the tenant during the subsistence of the lease. That's the easy part. And the thing is, people misinterpret this so severely bad that inspections in the rental market, in the industry that I'm seeing from different estate agencies as well as from private landlords, is interpretations on this that is absolutely wild about midterm inspections and things like that the Act does not deal with. So what the Act says, in short, is you need to do an entry inspection prior to the tenant taking occupation of the premises, and then you record all the defects. Now, one of the misunderstandings here already is that you do a list of defects that the landlord needs to fix. That's not what the Act says. What the Act says is it's a recordal, and you will see that in terms of the TPN leaseback, residential leaseback as well, which most of the national agencies are using as well. We simply say this is a recordal of the defects. Why? So the landlord can't say, well, that window is now cracked when you moved out. The tenant must be able to say it was cracked when I moved in, so this, Mr. Landlord, is a you problem. It's as simple as that. So it's a recordal of the defects, so we know when the tenant vacates which defects did the tenant cause. It's as simple as that. And then at the end, we need to do an exit inspection. I know we're going to go into a bit more detail at a later stage. but your exit inspection is then a recordal of the defects at that time, so we can show these defects recorded by the tenant. Let's deduct that from the deposit, and Bob is your uncle. That's the short nutshell version of the Act.
And something to also then bear in mind, touching on the Act further, is that if something is not recorded in the inspection, at the incoming inspection, it's almost deemed as though the property is in a good state of repair. 100%. So a lot of people and a lot of questions that we've been getting at TPN are, you didn't take a photo of an absolutely clean and perfect wall, therefore you can't prove that it was in a good state of repair. Yes. But the fact that you did a joint inspection with your tenant and landlord both present, the fact that it wasn't noted anywhere that that wall was damaged means we have a property that's in a good state. And I'm sure, Ines, from the terms of a practical point of view, you must have a lot of situations where tenants maybe just don't come to the incoming inspection or don't come to the outgoing inspection. What, from a practical point, do you do if someone, say, refuses to come to an inspection? How do you handle that in a practical sense?
So in a practical sense, it's really just advising the tenant of the risk of not attending an inspection and the protection that it gives them as a tenant to be there. So practically, that's what we can do.
Exactly. So from an incoming inspection point of view, if they're not there to record that there's a big crack in the wall, then they're not there. And you can note on your incoming inspection, specifically tenant failed to appear despite notification, and then that's essentially to their detriment when they go forward. David, obviously things are slightly different from let's say from an authority point of view. So where the Act says that those inspections must be done jointly with tenant and landlord, from your side of things, maybe you can give us a little brief overview of Property Inspect first of all and what you do, and then explain to us how you deal with an incoming inspection where both parties need to be present.
Yeah. Thanks, Greg. Yes, so Property Inspect is inspection software, and it's utilized by rental agents, but also by the emerging market of outsourced inspection companies, and that's a market that we see in other countries, and it's a market that's starting to emerge in South Africa, and I think we'll go into that in a little bit of detail later. We also have a training academy where we teach people on how to do it, but not only how to do it, why is it important, and how can you use your inspection document as an opportunity to attract more mandates by showing potential customers of yours how you give them access to the deposit by doing thorough inspections. And we've just talked about attaching or the defects that need to be recorded. Now, I always think about the inspection document. Who are you actually doing this inspection document for? Are you doing it for the landlord? Are you doing it for the agent? Are you doing it for the property? And I always think about the inspection document as being prepared for someone who's going to mediate on a dispute, because that's really the only time you're going to refer back to it. And of course, we know that this is where all the disputes happen, because you're dealing with people, you're dealing with deposits, you're dealing with accusing people of things.
Exactly.
So this is an emotional aspect. So this is where all the disputes arise. And we always try to encourage people to go beyond what the Rental Housing Act says by doing more of a quick, and it's very difficult because you've got time constraints as well, and maybe we'll go into more detail later. But doing more of recording the conditions so that you can go back and prove it. We've just said that you assume it's in good condition. That's fine. It's so much easier when you've got a photo of a green wall, and when they move out, it's a blue wall. You can't really remember. You've got the evidence of the photo. So just going that little bit beyond.
Exactly. And as you say, with time constraints, you have a situation, I'm sure in practice you see it, where you have a tenant who's leaving in the morning of a day, and then the new tenant's coming in after that other tenant has moved out. So the Act also says that you can't use a previous tenant's outgoing inspection as your incoming inspection. So practically speaking, you'd need to do 2 inspections. So when you talk about time constraints, it really is a big worry for someone, especially a property practitioner that's involved. So from a practical point of view then, Silna, what makes a successful inspection of a property?
Well, Greg, I think the first part of that answer is make sure you have enough time. We were talking about the time constraints now, and I see it, and I really have so much empathy for the rental agents who has to arrange the key delivery, the key handover. This one is now didn't give the proof of payment for the first month's rental. And then so many things are happening. I always feel for my friends, the rental agents. At the end of the month and the beginning of the next month, moving weekend is always a crazy weekend. My phone obviously goes mad that weekend, but that's why I feel for the agents then. And the biggest thing is to stop and make time. And I think that is exactly why I'm extremely good friends with David and the independent inspector companies, because the agent doesn't have time and you can't make time. That's now the one thing that I've learned in life. You only have so many hours on that move weekend that you can inspect. And that's exactly why I'm always a fan of outsourced inspections, because as we rightly said, to be able to prove that the wall was in a perfect condition, there wasn't a crack, even though there's an assumption, when we run to the tribunal, when the tenant ends up at the tribunal, to try and convince a commissioner in the tribunal that, well, we need to assume that it was in good condition, now it can fall to either way. And now it lands a little bit on how does the commissioner in the tribunal feel this morning? What did he have for breakfast? And I don't like law that works like that. I like law where we can prove this was the actual condition. So practically, I would rather make time by not creating more hours, but actually outsourcing. And if you can't, I know of some rental agencies that has like their own inspectors, internal inspectors in their agencies. As long as those guys know exactly how to inspect properly. I think I've told the story many a times of my own property, one of my own properties that I purchased, and I myself buggered up an inspection to a point where I really actually caused a lot of damage to myself. And I think in the industry it's a little weird if I say I messed up an inspection. But if I can't do an inspection properly, I think that's the thing. You need to know you need time, because if you do not open every cupboard, if you do not open every tap, if you don't let the taps run to make sure the water actually gets warm, you're not going to be able to record everything properly, and that's where your problem comes in.
Exactly. And I think our viewers, when you see Silna out in the world in the future, go and ask her about her property inspection, see if you can get some details out of it. David, you're about to
I was
add.
just going to build on that. Time is the number one thing in what makes a successful inspection. But to build on that, what you need is a plan. So you can't just arrive at a property and go, I'm going to do an inspection. And where do I start? How do I need to be effective? I need to use my time properly. So I need a plan. What is the process that I'm going to follow? And when you've got a very simple process, it becomes quick and easy. It becomes habit. So who's ever doing the inspection, and I think we'll touch on it later, but whether it's an internal inspector, whether it's the agent, whether it's an outsourced inspection company, there are pros and cons to all of those. But having a plan, having a process, and then having a system after you've conducted it as to where and how you're going to store it, how you're going to distribute it, how you're going to reduce your time off-site once you've done the inspection. And then, of course, what makes a successful inspection is the physical report itself, which we can go into maybe a little bit later.
Yeah, definitely.
I was going to weigh in there as well, because as real estate agents, we are property professionals, and that's where our skill set lies. And that's where we should keep our skill set. Your skill set lies in doing a property inspection, and that's why we should use external inspectors.
I actually thought of an example. I don't know if this is a good example, but let's say you need to go buy a dishwasher, a new dishwasher. Yes. Your dishwasher's packed up, and you go to Hirsch's, and there's a salesperson, and they show you all these different kind of dishwashers, and they tell you the different things about it and the prices, and you buy it, and they do a really good job selling it to you. And they say, we'll organize delivery. And then you go home, 2 days later it arrives, and it's the same person coming to do the delivery and do the installation and remove it. It's different skill sets, exactly what you said.
Absolutely.
And I think that's quite important to understand. And that's why, look, some agents do love to do it. You'll know, Ines, from your practical experience. But some agencies, we see it all the time, have someone in their business that is tasked with that job, often linked to maintenance.
Yes,
Absolutely.
and also the liability behind it as well.
Yeah. Of course. So we have a couple of questions that have come in. So the one is a particular thing that I think we see a lot when we look at other leases. So first of all, we have conducted our first poll, and the first poll was, do you make use of the TPN lease pack? And the results are 64% of the people watching do, no is 24%, and 10% are not yet but should. So those no's that are on 24%, those should actually be shifted automatically to no, but you should. Silna, so one of the questions that came from Jacques van Zyl is, why do some contracts allow 7 days after occupation for the tenant to notify of any defects, and then when you have those, and then those sort of constitute your defect list for the purposes of an inspection?
So, John, the reason why that is in there, and we have a similar clause in the TPN lease pack, is because when you don't use David for your inspection, and the agent or the landlord personally and the tenant does the inspection, they don't know exactly how to do it because they don't have the system or the know-how. They run quickly through the place. They're like, okay, it seems like the place has walls and doors and windows, lacquer, everything is fine. And as the tenant then lives in the place, he realizes, oh my goodness, but here's a cracked tile. Here is this and that and the other. And that forms part of the recordal. Now, here's a trick, something specific in the lease pack that makes it unique, potentially, or just a unique safeguard there, is to once again confirm that those reports in 7 days by the tenant to the landlord will simply form part of the recordal, and it's not a notice to repair. And I think that's a big difference. And if the lease agreement is drafted in such a way to say, if something was missed in a period of 7 days, we can add it to the list and the tenant won't suffer those damages by having to fix something he didn't break, that's fine, but just make sure the lease isn't accidentally drafted in a way where it seems like it places an obligation on the landlord to repair, and then if the landlord doesn't repair, the landlord is in breach, and we obviously don't want that.
It's also a nice practical way to, first it's nice, but it's a way to get signatures on site as well. You know, sometimes tenants are hesitant to sign, they want to check the report, they want to see it, they want to walk around, and if they feel that they've got that period to say what they need to say, it just makes the signature on the document a lot easier.
I think an important differentiation here is that the 7 days that is in there doesn't replace your inspection. It supplements your inspection. So you shouldn't have in your contract that there won't be an incoming inspection at all. The tenant just has to notify you of the damage in the 7 days. I think that's the distinction in the question.
And you make a valid point, because that's not legislated. Hey? The 7 days isn't part of the Act. So if you don't do the joint inspection in terms of the Act, you didn't comply with the Act. I think that's a very valid point.
Exactly. Sorry,
I was just going to say, what we do on our software is we give the agencies the ability to turn on and off tenant commenting for a period of time. So when the reports are distributed to the tenant, they can actually go into the web document, note everything that they need, and the agent gets a notification. So that's an optional setting to cover exactly that.
So it builds into another question that we got, that is it acceptable to give the tenant a snag list to verify sign and return? Not all tenants can be present in entry and exit inspections. And it's a similar sort of process. You should have your entry inspection that's done, but then your snag list could be that essentially give us 7 days to get something back.
100%. And the Act doesn't say anything around a snag list. And I think something important, and allow me to be the boring lawyer for the second here. Thanks, Greg, for that laugh.
Carry on.
The boring lawyer. But I think importantly, we can't contract out of legislation. We can't adjust an Act to the way we feel comfortable. And sadly, the Act doesn't say, let's do a snag list or let's find a practical way. The Act says at a convenient, mutually convenient time. So what the Act envisions is find a mutually convenient time to do a joint inspection. That is a requirement in terms of the Act.
Excellent. So we have another question which came in, which I think is maybe getting a little bit confused with something that we're going to touch on now. But it is, so the landlord does not need to sign a new defects list with every management agreement that is signed. It can be done with the tenant before they move in. So the confusion here is that the new Property Practitioners Act has come into play.
Yes.
And that Property Practitioners Act doesn't replace inspections, but it introduces something new called the mandatory disclosure form. And that mandatory disclosure form is something that needs to be provided by a landlord prior to the lease being signed. So I think Ines, you can maybe touch on the difference here between the inspections that need to be done and the mandatory disclosure forms that you as a property practitioner need to obtain.
Yeah, so the mandated disclosure form is probably a lot newer in the rental realm of things than what it is in the sales realm of things. I know that they introduced the Property Practitioners Act in 2019, I think it was, so now I'm not the legal expert. And a lot of real estate companies adopted it in the sales environment.
Yes.
So the sales agents are very used to completing this, let me correct that, not the sales agent. The seller or the owner of the property is used to completing this mandatory disclosure. And it's really just to note high-level items in the house, such as, are there any roof leaks, are there building plans, are there any plumbing issues? And it doesn't detract from footsteps or anything like that. It's merely just a disclosure. I think where the confusion comes in is that it's now also a legal requirement, not legal, but they've always had the right. I mean, sellers have always had the right to inspect their property, buyers have always had the right to inspect the property, but now it's written into the mandatory disclosure.
Exactly.
And it brings in confusion between an inspection of a property for a buyer versus what the Rental Housing Act says for inspections that the tenant and the landlord have to be present.
Exactly.
Yeah.
So it's two very separate aspects of dealing with a property. And I think, Silna, you can also confirm this. With a mandatory disclosure form, it's the landlord that is ultimately the one who needs to sign this and provide it and ultimately bear the risk as well. So in terms of that mandatory disclosure form then, would you recommend that be outsourced to an inspector, or do you do that mandatory disclosure form yourself? Ines, do you?
So when it comes to the rental environment, if we are managing the property, we obviously got a history in terms of that property with defects. We've been maintaining the property. We've been sending out maintenance people. So we would assist the landlord in terms of the completion of the disclosure. But at the end of the day, the landlord is responsible to make those disclosures to the tenant and to sign the form.
Exactly.
Yeah.
Then David, from a property inspect and an outsourced inspections side of things, how has this introduction of a mandatory disclosure form affected your business and the business of independent inspectors out there? Does it hurt or does it help?
It does both, really, I suppose. It helps in the fact that it's created a little bit of anxiety, I guess, with property practitioners in terms of risk, in terms of liability, and people are trying to get their processes in place when it comes to inspections. And whether we're talking about the mandatory disclosure with the seller or the landlord, or the ingoing and outgoing, or an independent inspection at the point of sale, these are now topics that are being discussed, and the processes and the options are starting to play out here in South Africa, I think.
Exactly. So then, Silna, from a point of view of that mandatory disclosure form, from a legal aspect, let's say something's not stipulated on that disclosure form. And I think maybe also touch on the difference between a patent and a latent defect.
All the joyful things.
All the fun things for the lawyers, yes.
I'm just going to irritate you first and
Please.
just take one step back to the interaction between the Rental Housing Act and the PPA. Ines, you said it so perfectly, but in terms of the legislation, it's crucial to know. So since 2019, we knew about the Property Practitioners Act. It was promulgated in now the 14th of Jan to be promulgated effective from the 1st of Feb 2022. And from that moment, Section 67 of the Property Practitioners Act is absolutely essential. And I need to mention that to come right back to your question.
Please do.
Because Section 67 of the Property Practitioners Act says that a property practitioner, so your rental agent, may not accept a mandate for sale or rentals. And in the Act, it specifically refers to both sales and rentals. It says a seller or a lessor. So you may not accept that mandate unless the seller or the lessor provides you with a signed copy of the mandatory disclosure form. So now I get the question often from rental agents. They say, Silna, it's such a pain. I can't get my landlords to sign a mandate agreement. Well, now at least we have an act to say, you know what, Mr. Landlord, I see you. I understand that it frustrates you. It's similar to paying tax. The fact that you don't like it doesn't mean you cannot do it. So here you go. I may not accept your mandate unless you provide me with this mandatory disclosure form. And then obviously the Rental Housing Act, completely separate. This is about the relationship between the landlord and the tenant. The mandatory disclosure form is about the relationship between the seller or the landlord and the rental agent, the property practitioner. And the catch in all of this is actually quite scary. What's happening is, if you do not comply with Section 67 of the Property Practitioners Act, so you accept as a property practitioner a mandate to sell or rent without the written mandatory disclosure form attached to your mandate agreement, and there are defects that cause damage to the tenant or the or the purchaser, and they suffer financial or other loss as a result of your failure to have this document, that means you as the property practitioner, now in terms of the Act, receives liability and draw personal liability towards yourself, which wasn't the case prior to the Property Practitioners Act being promulgated. Now we can have 1.5 million arguments about, is this fair, is it not fair? It is what it is. So it's irrelevant whether you feel happy about it or not. And I'm sorry to be such a blunt lawyer today, but we have to comply with the Act. And it's more important to be aware of this as a property practitioner so you can protect yourself rather than argue against it and in a year or so end up with a claim against you in your personal capacity. We would not want that.
But Silna, if I can weigh in there as well, although maybe not 100% linked to it because now this mandatory disclosure form is there, real estate agents have always had a responsibility to disclose what they know and what they should know in the ordinary course of their business, and that hasn't changed. That portion of the Code of Conduct is still in the Property Practitioners Act.
Exactly.
Exactly, it's beautiful, thank you. And that's exactly it. And sorry, Greg, I didn't answer your latent and patent part of the question. So your defects, that doesn't change. The Act doesn't take away from any right that a purchaser or a tenant had against a landlord or a seller in any event. It's still there. But the fact that we now do this mandatory disclosure form also limits the risk with regards to latent and patent defects. Again, full circling back to the professional inspectors. I don't know about you guys, but I have never ever climbed into a roof before I make an offer to purchase a property. That's never happened in my life. But if you want to do a proper full inspection and you want to make sure your disclosure form is complete, protecting both landlord and tenant, protecting both seller and purchaser, you want to make sure somebody climbs into the roof, check for termites and all those funny things that cause problems, which you've missed completely. So it doesn't take away from food stewards and the potential claims that the parties would have had. Actually, it enforces it and at the same time creates another layer of protection to both parties.
I was just going to say a nice simple way to always think of, first of all, to remember which is a patent and what is patent, what is latent, and you get a bit confused, especially if you're new to the industry. But I always think of patent. You might have heard the phrase from your teachers or from your parents or your friends. Isn't that patently obvious? And that's just a simple way to remember. Patent is obvious. You should be able to see it if you're looking. You should be able to see it with the naked eye. And you don't need to be an expert to see a patent defect. You don't need a moisture detector that you push to the wall. It's something that you can see. And then the way I always think about the latent defects, is just association, latent, lie, hidden. So, that's just a nice way to remember the difference. And those latent defects are either going to be found by professional inspectors or by someone living at the property over a period of time. If the roof leaks when it's raining and the wind's blowing from the west, you're only going to find that out by living in the property.
Exactly. I think that's a perfect description. I'm probably going to steal it for when I give advice to people in the future. Yeah, thank you so much. So we've got a very practical question here from Derek, and I'm sure that it's something that a lot of people will ask. But when you do these outsourced inspections where you pay someone to go climbing through your roof beams, who's going to pay for that? down to the bottom line.
You're looking at me, so I'm sure it's a me question.
I think all of you, any of you can answer that.
All of us. I'll start by saying the easiest answer is the party that instructed the inspector.
Absolutely.
Whoever wants it the most.
Yeah.
Exactly.
And of course, that's something that you can include in contracts as well, and
Yes.
should be included in your legal agreements that you state. You know, if an inspection is going to be done outsourced, you can include that.
It's such a difficult one because there's a cost involved, and there's also the perception of the risk of a sale falling through. You know, for a professional inspector to come in. Personally, I would never buy a property without having an inspection done. But of course, from the property practitioner's side, it's risky because if you receive an offer and it's subject to a satisfactory inspection, you can pick out anything in there that you don't like and withdraw from the transaction.
Exactly.
So that's why there's this kind of fear of it, I suppose.
Yeah, 100% of fear. But it becomes a negotiation point. So we shouldn't be fearful of professional property inspections. We actually should welcome them. The reason being because it then really protects us in terms of the patent and the latent defects that come back in terms of, you know, footstrips and everything like that. There's that 100% protection there. And it really does become a negotiation point. And because we are property professionals, property practitioning professionals, we should be able to mitigate those risks.
Yes.
Furthermore, if one purchaser has requested a report and we are privy to the knowledge in that report as practitioners, we go straight back to the code of conduct and our duty to disclose. So whether this buyer who's requested the report proceeds with the deal or not, the information that we have at hand still now needs to get disclosed.
Yes.
So we really should just welcome it,
Yes.
to be honest, and work our way around it.
Absolutely.
From a rental perspective, it's obviously different
Yeah.
because the landlord's responsibility to maintain isn't taken away by a disclosure.
Absolutely. We have a question that's coming from Celine. So I'm going to touch on the main point of this question, which is an outgoing inspection. They've got to do an outgoing inspection, but the tenant's furniture is still in the property. So it's making it very difficult for them to get in. So in terms of, I think this is a bit of a legislated question, it says specifically that an outgoing inspection must be conducted within 3 days of the expiry of the lease at a time that's mutually agreeable between the parties. So from a practical point of view, there's a little bit of confusion out there in the industry. Maybe we can touch on that.
Would you mind if I go all the way to pre-inspection?
Go back as far as you need.
Ines, you know, I've been working with you guys for long enough, and I get this question so often. So let me start there. This fallacy, and really it's a fallacy in the industry, specifically on rentals, that prior to so close to the end of the lease agreement, the rental agent must go through the property and do a pre-inspection. Now, I've been doing rentals for a bit of time in my life, and that is really not legislated. There is nothing in the Rental Housing Act, not in the Act, not in the regulations, not even in the current draft regulations, nothing about this pre-exit inspection. Now, the belief in the industry, and I'm sorry for everybody that I'm shocking, oh, it's a pleasure, I do what I can, but the belief in the industry is that the rental agent must do an inspection, pre-exit inspection, and then allow the tenant 3 days, somebody read the Act and saw the 3 days, allow the tenant this 3 days time period to rectify the problems in the property, and only then do you do the exit inspection. Now, this is not what the Act says. The Act says you do your entry inspection. The tenant must maintain the property during the subsistence of the lease. So when the globe goes out, you need to replace it when? Now, when it happens. When you crack the paint or you break a window, when do you fix it? When you break it. Then at the end, the stuff that you didn't fix, that the tenant broke during the subsistence of the lease agreement. Sorry, now the landlord may repair that, and this is what the Act says. and deduct that money from the deposit. Once again, the landlord doesn't have to provide the tenant with 3 quotes, and then the tenant chooses which contractor to use, or the tenant gets time to fix it. Why? Because the tenant is going to be out of here in 3 days max. So he's going to use the quickest, cheapest paint and the quickest, cheapest contractor he can get his hands on, affecting the investment of the landlord. This is not fair, and this is why the Act says when those things weren't repaired, now we deduct that from the deposit based on the exit inspection, which has to be done within a time period of 3 days prior to the expiry date of the lease agreement. But the Act does say at a mutually convenient time. Now, I agree, to inspect a property that's still full of stuff and with posters and stuff on the wall, it's really easy. Even I can, hide a defect with a poster.
Exactly.
So you do want to do it when the property is vacant, or at least very close to vacant. So find then a mutually convenient time. Please, please, please make those arrangements on email, in writing, and say, hello, I see you are moving out on Friday afternoon. Can we agree that we do the exit inspection at 4 when most of the things are out of the property? If the tenant then says, you know what, it's not convenient for me, find a time that is. And then the Act says, if the tenant doesn't attend the inspection that you've arranged, and this is why I want it to be in writing, you as the landlord or the agent, property practitioner, mandated on behalf of the landlord, you do the inspection, and then it will be deemed as if the tenant was there. You just need to provide him with a copy of the exit inspection, and then only the receipts of the money that was deducted from the deposit for the repairs that had to be done. So listen again, just the receipts. He doesn't need the invoices, he doesn't need to see the quotes, only the receipts, and you have complied with the Act.
And I think also, to make your life easy, there's a lease end date, right, and time, 12 o'clock on the 31st,
Exactly.
Which is actually another thing we should discuss, is why is there this tendency around month-end lease start dates, where if there's an opportunity to bring it into the middle of the month. But if it's 12 o'clock on the 31st, that is when the tenant should be out, and that is when the property should be returned in its state now, and that's when you should conduct your inspections. We have a lot of inspection companies that perform ingoing and outgoing inspections, and they absolutely insist on it. Everything needs to be out and the property needs to be clean. We will then come and we will then perform our inspection. So being quite firm, I think, with the tenant, just to make your life easier. It's very difficult when the tenant's moving things around, talking to you, etc., to perform it.
And I think it's also an important thing that you have in your lease agreement. So the TPN lease agreement specifically has a key handover time and date, which is very different from your termination date of your lease agreement. Your lease agreement could end technically at midnight on the last day of the lease. But when you put a key handover time and date into your contract, that enforces that the tenant must be there, the property must be in the condition it was handed over to them in, and you do your outgoing inspection there and then when everything is out of the property. It's a practical, good time to do it. So you don't need to say, if you misread the Act and say 3 days before the end of the lease, you can do it on that last day when it's still within those 3 days period. Something that, Silna, you touched on, which I think Ines can answer about, I'm sure you get a lot of queries from tenants sometimes that will say, oh, okay, I want to go back into the property, regain access after the expiry of my lease, and go and carry out repairs. Obviously, that's not something that's possible, but how do you deal with a tenant who wants to make... regain access to the unit to try and fix their stuff?
Thank goodness we've got Silna.
The answer in my head was, when you said practically, what do you do? Call Silna.
Call Silna.
Exactly.
And it happens, and it happens often.
Yeah.
We have tenants that say to us, actually, you have to provide me with 3 quotes. I should be given the opportunity to go back in and do the necessary repairs. And as Silna mentioned earlier, the responsibility on the tenant is throughout the subsistence of the lease and not at the end of the lease.
Exactly.
But practically, we have Silna.
Exactly.
Silna will then just say no.
we have lots of tenants that phone into TPN as well and ask this question. They say, I think it's unfair that I don't get an opportunity to fix the property. And you say to them, you've had an entire lease period to fix the property.
You had more than a year, my doggy.
Exactly. So it's an important distinction to make. Once the tenant has handed over those keys and they have left, you are now entitled to carry out those repairs yourself and have them fixed. And if it's the tenant's responsibility to pay for it, that's why you have the deposit to deduct from, and you go from there. You don't give them access back into the property. So we have sort of been doing an informal Q&A for the last 5-10 minutes, but this is now, we're going to get into the formal part of the Q&A for the session. So the feedback form will be posted in the chat now. Please make sure that you complete that feedback form and send it through to us. We obviously have a lot of questions coming through and we're discussing a lot. So if for whatever reason your question doesn't get answered, please feel free to email it to legal@tpn.co.za or helpdesk@tpn.co.za, and we'll make sure that our legal department will get back to you with an answer as soon as possible. So we're going to get into the Q&A properly now. So one question that we've got is a question for you, David. What is the most common defect that's missed in an inspection? It's a broad question.
I'm so excited.
You could even pick your top 3 if it makes it a bit easier.
My goodness me. I mean, let me start by saying what should go into an inspection report itself. Now I need my notes here. But if you walk into a property or into a room, there's certain things that you want to check to go beyond what the Rental Housing Act says in terms of just providing a defect. So this is what your agent should be doing, or your inspection company should be doing. Now, if you're an agent doing it, you're under time constraints, so you might use the very simplified form to do it more quickly. But you want to be checking the walls and the floors, the ceilings, the electrical. So when you take a photo of the ceiling, for example, put the lights on. You've got a photo of the ceiling, you can see the condition, and you can see that all the lights are working. Very, very important is the windows and the doors. I think that is where a huge problem comes. Sliding door that doesn't slide anymore. That's it. That's a huge one. So windows and doors. Now, what professional inspection companies would do is they would take a picture of the window open and the window closed. Same thing if there are blinds there. So you can just see that they're working. Because blinds open during the course of a tenancy, the wind blows through and they get quite damaged. And then of course any fixtures and fittings, and then the damage that you can see, right? That patent defect that we talked about. And the way to perform that in an inspection report is actually to signpost it. Picture a report, or you're going to a tribunal, you've got a dispute, there's a scratch, and it's just a picture of a scratch. Where is it? How big is it? Etc., etc. So we always advise signposting, which is pointing, taking it at an angle so you can see the size and the location of the issue. And then of course into the bathrooms, it's the plumbing. And I think Silna mentioned it earlier, switching on the taps, flushing the toilets, because that is often a big thing. They move in and now the toilet doesn't work, or et cetera, et cetera. And then of course, to answer your question, probably the oven and the extractors is a huge one. So those are the 2 things that I would bolt onto my traditional room inspection process or habit that I get into. So yeah, doors, window, keys. Keys.
And remotes.
Yes,
I must actually give you an example of something that actually happened to me back a while ago when I rented a property. So I moved in and everything looked great. It had been freshly painted, everything was lovely, and I went into the main bedroom and I closed the door behind me, and they had painted the insides of the door frames, and the door then wouldn't open, and as much as I pulled, it wouldn't actually open. But luckily I had a friend with me who managed to put some shoulder into it from the other side, and then we spent a little bit of time just sanding down the paper on the inside of the door to get it right. So it's something that I personally didn't even think to look at. I didn't think to go around as a tenant at the time and close and open doors and make sure that everything was
and Greg, it's very simple. When you check in a door, just take the key out, take a photo of the key.
Exactly.
And now you know when it's missing. In our reports on the software, we've got a section for meters and for keys. And all of this, because I think Ines, from your practical experience, that's probably one of the biggest issues.
Yes, keys, remotes, how many remotes did you get on entry, how many are you giving on exit, that type of thing. And it is often forgotten to be recorded. Often.
And the Act mentions keys by name. I mean, it's one of the few things that the Act specifically says you can use the deposit for. It does mention keys. And keys break. I actually recently broke a key. Well, I'm massively strong, but I'm not that strong. It doesn't take that much power to break a key, and it could easily happen. And if you don't have a photo to show, this key actually had all these word keys. That was my turn.
Are you able to take, Silna, then additional deposits? Obviously, an inspection report gives you access to the deposit, right? And getting as much deposit is in your benefit, obviously sensitive to the area that you work in. But are you able to increase the amount of deposit held by taking extra deposit for keys or utilities, etc.?
The TPN lease actually makes provision for that.
And the reason why we do that is especially the Act deals with one deposit. It's just one thing.
Exactly.
And the reason why we separate it in terms of the leaseback lease is specifically for that reason, to have a utility deposit specifically separate. Because, I mean, whether you replace a key or a remote or you're repainting a room, that's much of the muchness, and we're going to comply with the Act in any event. We then only need to refund the deposit within 14 days of restoration of the property. Now, if it's a key, restoration is relatively as quick as the guy at Builders Warehouse can do it. But to repaint might take a bit longer, or to replace a glass door or something might take longer. But your utility deposit is actually the tricky one, because you usually only get your last invoice about a month after the tenant vacates. So we need to comply with the Act, but in doing so we still need to protect the landlord, and that's the main reason why we separate them out. Please don't over separate. So what I mean by this is, don't do deposit for keys, deposit for this, deposit for utilities, deposit for eventually it ends
You could
up
have a
being
deposit
illogical.
for everything. Yes.
Exactly.
It's good to keep it bundled up as much as you can, because I mean the Act only speaks to a deposit. It doesn't speak to a key, utility, security, to every single item. So yeah, keep it fairly held together. We have another question that's come through from Palesa, which is, if you have a newly bought freestanding house in a complex, let's say it's just been developed, or let's even say it's a sectional title property, and you have a developer that's involved, how long would a developer have to attend to, say, a snag list after key handover has taken place on a property? And I think from a legal perspective, your developer is going to have slightly different aspects to deal with. Silna,
Exactly.
do you want to?
Well, Palesa, the truth is this is going to be dealt with in terms of your offer to purchase. So there's definitely not a one-size-fits-all answer here. And especially when you buy off-plan, that's where I typically suggest you really get into your due diligence. Make sure that the developer that's building is actually using somebody as the person that has to sign off on this is good and we can proceed. Actually, somebody that you can trust and that is independent from the developer, so you know that you are comfortable. And that obviously goes back to reputable property practitioners. If you work with a property practitioner, you've never, you read all sorts of bad reviews. If they then suddenly say, no, don't worry, we have this off-plan development, I would suggest that you sit tight and give it a bit of time to see what happens. If you work with reputable people, the chances that that's going to go south is much less, but still do your due diligence and make sure you read your contracts yellow, your offer to purchase, your lease agreement. Most of the dramas that I see, and I've been specializing in property law for a good 15 years now, but every single drama I see that has to go to court could have been resolved by actually implementing the terms of the contracts, or actually just reading it properly.
Exactly.
We can avoid so much drama by reading.
And if you want to have a good lease pack and a good sales pack, they are available on the TPN shop. You go to shop.tpn.co.za. They are available there for you. Silna has been involved with the drafting of both the residential and our sales pack. So if you ever need to go to court or litigate on anything, you know that at least those contracts have been drafted properly and correctly. We have a, yes.
I was just going to say, and it's not really answering the question in terms of a snag list, but I do think it's important to mention here that yes, a purchaser has a right when buying off-plan developments to submit a snag list in accordance with the agreement of sale, 100%. But we mustn't detract from the fact that it's not the same when you're buying a second-hand residential home. There's no such thing as a snag list.
Yes.
And there's no such thing as a snag list in terms of rentals either. You touched on it earlier, and I just wanted to drive home the point because in rentals, that snag list is the recordal and not the necessity to fix.
Exactly.
Sorry, I just felt it important to clear that up.
No, 100%.
That's very valid.
And your property that you're being handed over is not required to be in perfect condition.
No.
As long as you record what those defects are, so that the tenant that is currently staying in there is not responsible for rectifying them at the end, that recordal can be done. No one is entitled automatically to a perfect property.
Because that doesn't exist.
Exactly.
I mean,
There
even
is
a
always
brand
something.
new property, there is no such thing as a perfect
Exactly.
property. It's like human beings.
We have another question which has come through from Francesca, and I think I'm going to take this question. So it's how does the landlord do the disclosure form when they have been in the USA for the last 6 years? So something that's important to note is that you can do your inspections with a pre-approved outsourced inspection agency, but as you as the landlord signing that mandatory disclosure form, there is a very helpful product that TPN has called eSign. So we have an electronic signature platform that allows the landlord sitting anywhere in the world to complete the signature of their mandatory disclosure form via electronic means. So the landlord is completely within their rights to authorize a outsourced property inspector to go and carry out the inspection, to note all of the defects that will appear in the mandatory disclosure form, and then the owner of the property would then be able to sign it via the eSign platform, and they accept the risk of that damage that is there. We have another question which has come through, which is that generally the landlords are not available for move-in and move-out inspections. They don't want to have any part of it, and I think, again, this touches on your authority. So from a property practitioner's point of view, when you sign a lease agreement, the landlord is able to authorize a duly authorized agent to attend on their behalf.
Yes.
So your property practitioner is the person who can attend on their behalf.
Attend on their behalf, yeah.
Exactly. So we have another poll which has been conducted, which is which party is most challenging to complete to get the inspection process completed? And they asked, is it the tenant or is it the landlord? 72% say the tenant is the more challenging side of getting an inspection completed rather than a landlord, which is quite an interesting variation between the two. We have another question come through from Tony. I am a private landlord with 6 properties on long leases. Is there any requirement on him to make a mandatory disclosure form? So I think from a PPA perspective, Silna, you can answer this.
No, Tony, luckily, you don't have to. The only time you have to do the mandatory disclosure form is when a property practitioner steps in. So when you appoint an agent, and then prior to giving mandate to the agent, you have to complete the mandatory disclosure form. But I think at this point, it drives the point home perfectly about the difference between the inspection to complete the mandatory disclosure form and the entry and exit inspection envisioned in terms of the Rental Housing Act. So you still need to do your entry and exit inspections and complete the documentation as set out in terms of the Rental Housing Act, even though you don't have to do the mandatory disclosure form, because you are a private landlord and you don't have a property practitioner managing the property on your behalf.
And if you're a private landlord that has, for example, gone onto the TPN shop and purchased the TPN lease pack, there is an inspection document which is in there as well. It's separate from the mandatory disclosure form. You can ignore your mandatory disclosure form in there as a private landlord. You can focus on your rental application form, your lease agreement, your inspection document there. Or if you want to make use of an outsourced inspector as a private landlord, that's also within your rights to do. So those documents are available and in the residential lease pack on the TPN shop. So another question that's come through from Melissa. Does the mandatory disclosure form need to be completed annually every time the property becomes available again, or can you use the same form each time if there's no change to the property? I think, Silna, would you like to answer this?
It's
Or
an
Ines, would
unpopular,
you?
it's an unpopular answer, so I'll
Yes.
take it. That's why you have eviction lawyers on a couch with you, because they
Just
are
as
willing
well.
to be unpopular. You
100%.
have to. Every time you renew your mandate agreement, so once again, like we just mentioned to Tony, if you don't use a property practitioner, you don't have to do that. But every time you renew your mandate with the property practitioner, and remember, your mandate would typically be in line with your lease agreement. So you mandate, please, Ines, will you manage my property for the period of this lease agreement? At the end of that, to mandate again, to find a new tenant, a replacement tenant, you will have to do a mandatory disclosure form every time you mandate. And please remember, landlords, don't stay away from property practitioners because you don't want to do the mandatory disclosure form. They've got their ways and private inspectors to assist to do that on your behalf. Like we said, if you are abroad, for instance, and your property is in South Africa, there are ways of getting around that. But the more effort you put in, it feels like a lot more effort in the beginning, and it feels like such a load of effort. I promise you, you're going to save much more time during the subsistence of the lease by spending 2 or 3 extra hours in the beginning of the process.
Excellent. David, you had
I was just
something
going to
to add?
say, you know, without making it too daunting for the mandatory disclosure form when you're filling it in with the owner or the seller, it's really just honesty. I think you know, that's the bottom line. Do you know of any defects in your property? If you do, just declare them, because it could catch you out if you don't. There are ways to prove that when the wind's blowing this way and the rain comes in, you were aware of it because you were in the property 6 months ago. So it's just really not to be afraid of it, and just to request honesty.
Yeah, it's very important when you contract to always do it with good faith. That a contract is something that, you know, it belongs to 2 parties, and, you know, withholding something is only to your own detriment. Really.
Yes.
I think we have time for one more question before we wrap up, and I think, Ines, you can probably take this one. So, what if there's major damage from a tenant and the deposit does not cover the expenses? I'm sure this happens quite a lot, but from a practical side, what do you do?
That is quite a difficult question to answer, because practically we can withhold the entire deposit.
Of course.
We can send a letter of demand with all the invoices for the balance of the costs. But it then does boil down to whether or not what the quantum is, you know, absolutely what the quantum is in terms of the damages over and above the deposit, and whether or not the landlord is willing to litigate to get that money back, because it does boil down to that 100%.
Exactly.
If you are a property practitioner and you are placing a tenant in a furnished property, obviously you need to ensure that your rental deposit is sufficient to cover that. And in some instances, if you have potentially placed a tenant where the landlord has accepted the tenant even though there is a risk involved, increase the deposit. So better for protection at the beginning of the lease than fight at the end of the lease.
And I think that, yes,
Sorry.
go on, carry on.
Sorry,
No,
and obviously the tribunal, if it's
course.
Yes.
the rental housing tribunal instead of litigation, I'm the one that always says, don't litigate unless it's really necessary. The tribunal is absolutely amazing, and that's the perfect place for this. That's why the SSLR actually recently started a department where we assist people to take matters to the tribunal, because since we started using the tribunal, I'm seeing amazing judgments at minimal cost, and that's in fact where we do want to be. Look at me saying tribunal. We
Yeah.
didn't see that one
No, we
coming.
didn't see that one coming.
Thank you so much.
Amazing.
Thank you so much, everyone. I think that's unfortunately all we have time for. If your question was missed, please remember you can email it to legal@tpn.co.za. You can email it to helpdesk@tpn.co.za. And remember, this is the first of a series of webinars that we're going to be doing on the practicalities of leasing. So keep an eye out in your email inboxes for the next invite that's going to come in. David, Silna, and Ines, thank you so much for joining us today. It was an excellent session and lovely to discuss it with you. Thank you so much, everyone.